Today's webcast is going to be difficult, emotional, but incredibly important. Following the tragic shooting at the Wake County Courthouse involving Gwen White and attorney Mary Harris and Jeffrey Whitley, conversations have exploded across the country about the legal process, especially involving litigants who represent themselves. There's also been a lot of conversation from victims of domestic violence about desperation, coercive control, frustration with the legal process, and emotional collapse during litigation. As a domestic violence attorney who practices right here in Wake County, North Carolina, and works with women in high conflict custody and divorce cases every single day, I need to say something clearly and lovingly to women walking through this process. Your pain is real. Your frustration is real. The system is imperfect. Some women truly are being abused, manipulated, financially controlled, or emotionally terrorized. But there are things you can do during litigation that will completely destroy your credibility, hurt your custody case, escalate danger, and potentially ruin your life. Today, we're going to talk honestly about what not to do. This webcast is legal education only and is not legal advice. I am not speaking about the merits of pending litigation or making factual findings about allegations in any case. I am using publicly discussed events as a learning opportunity for women navigating high conflict family court situations. One of the biggest mistakes women make is assuming that because they feel emotionally devastated, the court will emotionally respond in the same way. Family court does not operate emotionally. It operates through evidence, credibility, documentation, reasonableness, and patterns of behavior. This is incredibly hard for trauma survivors because trauma creates hypervigilance, fear, desperation, emotional flooding, black and white thinking, right? All or nothing, urgency, and panic. So, what happens? Many women begin trying to force people to see their pain. So, let's talk about what should you not do. So, the very first thing you should not do is we do not want to file excessive motions. Okay? We do not want to appear overly litigious. Now, this does not mean that if you need a protective order and an emergency custody order and maybe a complaint for custody at the same time, I'm not talking about that. When there's legitimate concern for safety and you need to do something quickly, such as filing for a protective order, a custody order, and a emergency custody order, those things need to be done maybe in tandem and at the same time and very quickly. I'm not talking about that. I'm talking about filing motion after motion after motion after motion. Many times the court will consider those Rule 11 or frivolous motions, right? ChatGPT is not your source for determining whether a motion is going to be frivolous or not. I generally recommend scheduling a consultation with an attorney before you're filing motions, even if you can't afford an attorney on retainer, to make sure that your motion is not going to be frivolous. But filing motion after motion every time you are upset is not strategy. Judges begin to see emotional escalation, inability to regulate, inability to co-parent, and litigation abuse. Even if you are genuinely hurting, the court wants to see organization, restraint, relevance, and focus. So number 2, what you should also not do. Do not contact every agency, school, employer, church, or government official. This is one of the biggest credibility destroyers in family court is when someone starts contacting CPS repeatedly, schools repeatedly, employers, the ex's employer, the abuser's employer, military command, licensing boards, your child's therapist, their licensing board, the pediatrician's licensing board, your lawyer's licensing board, contacting the state bar, contacting judicial standards, churches, trying to contact the judges directly, media outlets, going to the news and contacting them saying you want to make a statement or you have a story or a report all about your custody case. bad mouthing your judge or your attorney or the judicial process while you're in active litigation. These are not good ideas. Contacting legislators, state representatives, the mayor, the governor, or multiple agencies over and over again. The governor, the mayor, state representatives, all of these people are not likely going to see your emails, especially the governor. They have bigger issues that they're dealing with. Custody case is not going to be one of those issues. So they're not going to see your email, but you're copying those people on your emails with your abuser, with your attorney, or with court officials. It's going to get back to the judge that you're doing that, and it's going to make you look unstable. So especially when allegations are unsubstantiated, this begins to look like either obsessive or retaliatory behavior rather than protective. It also starts to look unstable, right? That there might be a mental health issue that the court needs to be concerned about. So, number 3, do not post everything on social media. Social media is one of the fastest ways to lose credibility. When you're posting rants about your ex, about abusers, about the judge, about the court system, you're exposing your case online. You're attacking your ex publicly. You're recruiting followers into your custody case, or you create a constant online narrative. It can make you appear emotionally unstable or focused on revenge instead of your children. And it also puts your children in the middle of your litigation, which the courts do not like. If you are in the middle of litigation, this is not the time to be making public social statements. Save that until after the litigation is over. Okay, number 4, what not to do. Do not make false or exaggerated claims against the abuser. And I'm saying false, meaning not true, or exaggerated, so beyond the scope of what's actually happened. This is critical. If you exaggerate allegations, if you overstate events, if you make claims you cannot support with actual evidence, eyewitness testimony, documents, you damage your real credibility when actual abuse exists. So judges see hundreds of cases. And once credibility is damaged, it is very difficult to recover. Number 5, do not let your case become your entire identity. Okay. When litigation becomes your entire identity, your nervous system starts living in permanent crisis mode. Every email feels catastrophic. Every hearing feels like life or death. Every disagreement becomes proof of abuse. But this is not sustainable emotionally or strategically. Number 6, do not threaten, harass, follow, or confront people. This should go without saying, but do not threaten attorneys, threaten judges, threaten your ex, harass court staff, follow people, record obsessively, become aggressive, become the initiator, or engage in intimidating behavior. It will destroy your case and potentially expose you to criminal consequences. You cannot take matters into your own hands like Gwen White did. She did not achieve her overall objective. The next tip that I have for you is do not start filing multiple lawsuits against judges and attorneys, especially federal lawsuits for civil rights violations. This is usually a huge red flag that we see when we start to see someone unraveling psychologically. When we have mental health concerns, we usually will typically see federal lawsuits being filed. And a judge is not going to forget when they're named as a defendant in a lawsuit against them that you have filed against them as the plaintiff or the petitioner, whether that's in state court or federal court. If you're in active litigation, this is not a good idea. Now, let's talk about when reporting is absolutely appropriate. I want to be very clear, especially when we're talking about abuse, coercive control, and domestic violence. There are times when filing reports is absolutely appropriate and necessary. You should report and you should file, when there are issues of physical abuse, credible threats, strangulation, stalking, child abuse, sexual abuse, violation of protective orders, kidnapping risk, threats of homicide or suicide, weapon threats, or genuine safety concerns. That is not what I'm talking about here. Those are absolutely appropriate motions, appropriate calls to CPS, appropriate calls to law enforcement agencies. That's not what I'm talking about here. I'm talking about when you're in the midst of active litigation, right? And there's already been a DVPO or protective order filed. There's already been a custody action that started. You're in the thick of it, and you have ingrained yourself so much. Again, the custody action or the lawsuit has become an integral part of who you are, and you're less child focused, and you become obsessed with the litigation itself. You're allowing the litigation to completely overtake your life. This is not a good thing. Okay. Victims should never feel ashamed for seeking protection, but there is a difference between strategic safety reporting and emotional escalation. So, what are the courts really looking for? The court is constantly evaluating who appears regulated, right? Who appears reasonable? Who can prioritize the children's needs and actually take care of the children? Who can make good decisions? Who has good judgment? Who has good insight? Who doesn't? And who can follow orders, right? Who's going to have respect for the court and not try to take matters into their own hands? Even when you don't agree with the court, you don't like the decisions they're making, you're going to have multiple hearings. You're going to have an opportunity to continue to make impressions upon the court. So just because you have a bad day in court, don't let that ruin the long-term outcome of the case for your children. They're going to be looking at who communicates appropriately, who's escalating the conflict, who appears credible, and who appears retaliatory. You don't want to feed into his narrative that you're unstable, that you're the crazy one, that you're the problem causer, right? We don't want to do that. And this is a painful truth because sometimes the calmer person appears more credible even when they are the abuser. And that is why emotional discipline matters so much. So here's what to do instead. Instead of emotional escalation, document calmly, organize evidence, keep timelines, use neutral communication, work with professionals, get a therapist, a psychologist, a psychiatrist, get on medication if you feel like you need to. And that is absolutely okay. Sometimes we all need a life raft when we're going through something as stressful as family court. Focus on long-term strategy. Know that by implementing these measures, you're being proactive. We always want to be proactive instead of reactive. We want to learn the legal system, right? That's going to help empower us. Stay spiritually grounded. You don't win by becoming louder. You win by becoming clearer. I also want to speak to the women who feel completely hopeless right now. You may feel unseen, unheard, betrayed, exhausted, financially broken, terrified for your children, and emotionally overwhelmed. But desperation is not direction. And God does not call us to chaos, revenge, violence, or destruction. He calls us to wisdom, self-control, discernment, perseverance, truth, and endurance. And that is exactly why I created Equipped to Stand, because women need legal education, structure, guidance, strategy, emotional grounding, and understanding of how the legal system actually works. Over 12 weeks, I teach women what helps their cases, what hurts their cases, how to document effectively, how to communicate strategically, how to organize evidence, and how to stop emotionally reacting in ways that damage credibility. You do not have to navigate this alone. If this webcast helped you, please like us, subscribe, and share it with another woman who may need to hear this message. And remember, you cannot defeat abuse by losing yourself in the process. Stay grounded, stay strategic, stay disciplined, and keep standing. We'll see you next time at 7 o'clock p.m. Eastern Standard Time right here at Live Free Legal on YouTube for my next webcast. Stay safe.